Representative Jim Jordan put Attorney General Pam Bondi on the spot with a rapid series of questions that moved from constitutional rights to a controversial church protest and then into an entirely different dispute involving former CIA Director John Brennan. But the most important moment came when Jordan stopped reviewing the past and asked Bondi the question hanging over the exchange. Could Brennan actually face an indictment? Bondi had an answer, but it was nowhere near the direct yes or no Jordan appeared to be seeking. Instead, she confirmed something significant while leaving the biggest question unresolved.
Madam Attorney General, you're not allowed to exercise your constitutional rights in a way that tramples on someone else's, are you?
No.
No, you can't do that. I mean, you have a right to petition the government under the First Amendment. That doesn't mean you can come into this room and start screaming at Mr. Raskin or me or anybody else and disrupt a congressional hearing. You have a right to protest on the street, but that doesn't give you a right to go into the Capitol and disrupt Congress. Something these guys talk about every day. You can't do that. So when Don Lemon said that he was exercising his First Amendment free press rights, freedom of the press rights, that's not really accurate because he was trampling on other individuals' rights. Is that true?
Chairman, we will always protect our churches and the freedom of religion. And yes, that's accurate.
First right mentioned under the First Amendment, freedom of religion. Freedom to practice your faith the way you think the good Lord wants you to, right?
That's right, under the federal government.
And isn't it true that Mr. Lemon met at a shopping center with the rioters who entered City's Church in St. Paul, met with them prior to marching to the church?
He did meet, and this is a pending case right now, so I will only stick to what is in the four corners of the unsealed indictment, if I could, Chairman.
Yeah, I'm
There's a lot more that will come out. But under the four corners of the indictment, yes, he did. They had an operation called Operation Pull-Up. They said they were gearing for a resistance. They met in a parking lot, and they caravanned to a church on a Sunday morning when people were worshiping together.
And Mr. Lemon said that he live streamed before entering the church with the rioters. Didn't he say we're going to head to the operation? Didn't he say this he said this on camera, is that right?
Yes, Chairman,
yeah.
And more.
That he was in Minnesota and that, as you said, they were gearing up for an operation. So you can't do that. This is why this is, I think, so important that this guy be held accountable, and I think why you guys have charged him and indicted him. Moving to the second subject here, will John Brennan be indicted? Mr. Brennan lied to the committee, which you're not supposed to do, last Congress, and we deposed him. He definitely, 18 U.S.C. 1001, we're all familiar with it. He lied to the committee, and the Congress, and I think the country would like to know if, in fact, he's going to be indicted for lying. And here's why it's so important. I'll give you a chance to respond. Here's why it's so important. It wasn't just that he lied to us, it's what he lied to us about. He lied to us about when all this weaponization against the President of the United States started. He lied to us about the dossier, and specifically what role the dossier played in the intelligence community assessment. Because we know back when President Trump was first elected, first term, this is when it all started, which led to the Mueller and to the impeachment and to the Jack Smith and all the stuff that's happened in the last decade. But it began here, and he lied to Congress about the role he played. And I just want to read a couple of things he said during that deposition before I give you a chance to respond. Mr. Brennan, when asked a question, said the CIA was not involved at all with the dossier. He said it was their purview, FBI's purview, and not ours. He also said the CIA was very much opposed to having any reference or inclusion of the Steele dossier in the intelligence community assessment. Well, that's interesting because declassified information that was declassified this past summer by the CIA says something entirely different. It says, Brennan, I want to put this one up if we have it. It says, Brennan ultimately formalized his position in writing, stating that, quote, this is released by the CIA Director Ratcliffe, my bottom line is that what I believe that information warrants inclusion in the report. He was further asked by an CIA official. The same officer said when he approached the director and asked that the director refused to remove it after being explained this wasn't good. With the dossier's many flaws, he said, yes, but doesn't it ring true? So this is John Brennan using that document to change intelligence community assessment, which I think led to all the stuff we've seen over the last decade. And I think this committee in the country, Congress in the country, would like to know if Mr. Brennan is going to be indicted.
What I can confirm is that we have received a referral from you, Chairman Jordan, to investigate John Brennan. His attorneys have made some public statements, but the department is still bound, of course, by our longstanding policy of not discussing matters. What I will say today, I can't confirm nor deny whether there is a pending investigation, but what I will say is no one is above the law.
Mr. Chairman,
Weaponization has...
Jordan began by establishing a basic constitutional argument. Americans have powerful protections under the First Amendment, he said, but those protections do not give someone unlimited authority to interfere with everybody else. He used the congressional hearing itself as an example. Someone can disagree with lawmakers, criticize them, petition the government, or protest outside. But Jordan argued that those freedoms do not automatically create a right to enter a proceeding and prevent other people from exercising their own rights. Bondi agreed with the broader principle, and Jordan quickly connected that argument to religious freedom. That brought Don Lemon into the discussion. Jordan challenged the argument that press or First Amendment protections necessarily settle questions surrounding Lemon's conduct connected to a protest at a church in St. Paul, Minnesota. Bondi was careful because the matter she was discussing involves an active case. Rather than offering sweeping conclusions, she said she would stay within the boundaries of information contained in the unsealed charging material. That distinction matters. Allegations in a pending case are not the same as findings of guilt, and any defendants retain their legal rights as proceedings continue. Jordan nevertheless pressed forward. He asked about Lemon allegedly meeting with participants before they traveled to the church and referenced an operation described during the hearing as Operation Pull Up. Bondi said the publicly available case material described participants meeting in a parking area before traveling to the church while people were gathered for Sunday worship. Jordan's larger argument was straightforward. Journalism and protest receive major constitutional protection. But he contended that those protections do not automatically shield conduct if prosecutors believe it crossed a legal boundary. Whether prosecutors can ultimately establish their case is a question for the judicial process. Bondi then added a line that immediately raised the stakes. While limiting herself to the existing public material, she suggested that additional information could eventually emerge. She did not provide those details during the exchange, and that means it would be premature to speculate about what they might contain. Still, Jordan had accomplished his first objective. He had gotten the Attorney General to publicly defend the department's position while emphasizing religious freedom. Then, almost without warning, he changed subjects completely. Jordan turned directly to John Brennan, the former CIA director, and asked whether Brennan would be indicted. This was no longer a broad constitutional discussion. Jordan was referring to Brennan's previous testimony before Congress and allegations that Brennan had made inaccurate statements regarding the Steele dossier and its relationship to the intelligence community's work surrounding Russian interference in the 2016 election. Jordan argued that the issue was especially important because those events became part of years of political and investigative controversy surrounding Donald Trump's first presidency. Jordan's accusation centered on what Brennan had previously told congressional investigators. According to Jordan's description of the deposition, Brennan maintained that the CIA was not responsible for the dossier and indicated that CIA officials opposed referencing or incorporating it into the intelligence community assessment. Jordan then contrasted those statements with information that was later declassified. His argument was that the newer material presented a significantly different picture of Brennan's involvement. But that was Jordan's interpretation of the evidence, not a determination of criminal liability. Jordan highlighted declassified CIA material that he said showed Brennan supported, including information connected to the dossier. According to the material Jordan referenced, Brennan expressed the view that the information warranted inclusion in the report. Jordan also cited an account suggesting concerns had been raised internally about weaknesses associated with the dossier, yet Brennan still believed aspects of it were relevant. For Jordan, that apparent difference was the heart of the matter. If Brennan's congressional testimony and the declassified record were inconsistent, Jordan wanted the Justice Department to determine whether that inconsistency crossed a legal line. That distinction is critical because congressional testimony disputes can become complicated very quickly. A disagreement, inaccurate recollection, conflicting interpretation, or contradictory statement does not automatically establish a prosecutable offense. Investigators would have to examine the precise questions asked, Brennan's exact answers, the surrounding context, the available documents, his knowledge at the time, and whatever legal requirements apply. Jordan was making the case for scrutiny. He was not delivering a judicial finding, and that made Bondi's response even more important. Bondi confirmed that the Justice Department had received a referral from Chairman Jordan concerning Brennan. That was the clearest piece of new information in her answer. She also acknowledged that Brennan's attorneys had made public statements. But when Jordan's question reached the crucial issue, whether an investigation existed or whether an indictment might follow, Bondi invoked long-standing Justice Department policy. She said she could neither confirm nor deny whether there was a pending investigation. That response created an unusual dynamic. Jordan had spent much of his allotted time building toward one direct question. He reviewed Brennan's earlier testimony. He introduced declassified information. He explained why he believed the discrepancy mattered. And then the Attorney General confirmed receipt of Jordan's referral while refusing to reveal what, if anything, prosecutors were doing with it. Bondi finished with a broader message that no one is above the law and declared that what she described as government weaponization had ended. For Jordan, however, the unanswered portion may have been just as important as the answer he received. Bondi did not announce charges. She did not confirm an investigation. She did not predict what prosecutors might ultimately decide. That restraint matters because a congressional referral itself does not establish wrongdoing and does not require the Justice Department to prosecute anyone. It essentially asks federal authorities to examine information and determine whether additional action is appropriate. The exchange also demonstrated why oversight hearings can become politically explosive. Lawmakers can publicly confront cabinet officials with documents, previous testimony, and referrals, but prosecutors operate under different rules. Members of Congress can demand answers in real time. Justice Department officials may be unable or unwilling to discuss investigative decisions publicly. That tension was visible throughout Jordan's questioning. He wanted accountability expressed in concrete terms. Bondi repeatedly returned to the institutional limits governing what she could disclose. There was another important layer. Jordan connected the Brennan controversy to a much broader political history, arguing that decisions surrounding the dossier helped influence investigations and controversies that followed Trump's first election. Supporters of Jordan's position may see the newly declassified material as justification for renewed scrutiny. Critics may argue that politically charged disputes over intelligence assessments require careful context and should not be converted into assumptions of criminal conduct. The hearing itself could not resolve that debate. What it did provide was a clear snapshot of the Justice Department's current public position. Bondi confirmed the referral exists. She refused to confirm or deny an investigation. She declined to promise an indictment. And she repeatedly emphasized that legal standards should apply regardless of a person's status. Those answers may sound cautious, but caution from an attorney general discussing a potentially pending matter can be consequential. Saying too much could create legal complications or unfairly suggest that prosecutors have reached conclusions they have not actually reached. The Lemon portion of the hearing carried a similar lesson. Jordan strongly challenged the idea that invoking journalism or the First Amendment automatically resolves questions about conduct during a protest. Bondi supported the government's general position while restricting her comments because the case remains pending. The ultimate legal outcome must therefore depend on evidence and court proceedings, not the political intensity surrounding a congressional exchange. By the end, Jordan had connected two very different controversies through one central theme. where constitutional protection ends and legal accountability begins. With Lemon, Jordan argued that protected expression has limits when it interferes with other protected rights. With Brennan, he argued that former government officials should face scrutiny if congressional testimony appears inconsistent with later released records. Bondi largely agreed with the principle of equal accountability while refusing to predict the outcome of either legal process. Representative Jim Jordan, therefore, left the hearing with one major confirmation, but not the answer he most aggressively pursued. The Justice Department received his Brennan referral. Everything beyond that remains uncertain publicly. No indictment was announced in this exchange, no investigation was confirmed, and no court has established the allegation Jordan presented as a criminal offense. That unresolved gap is precisely what made the moment significant. Jordan put the evidence he considers important into the public record. Bondi acknowledged the referral, and then the Attorney General stopped at the boundary the Justice Department says it must respect. And that leaves the biggest question exactly where Jordan placed it. Will the Brennan referral eventually produce further action? Or will prosecutors conclude that the available evidence does not justify moving forward? The hearing could not answer that. What it showed instead was the difference between demanding accountability from a congressional microphone and establishing a case through the legal system. Jordan clearly wanted the first to lead to the second. Bondi made clear that, at least publicly, she was not prepared to say whether it ever will.